Morning, everyone. Justice Gustafson, you can hear us? Okay. This is the time for oral argument in cause DA 23-0462, City of Kalispell versus Sean Michael Doman. And Justice Rice was unable to be with us this morning. He will be participating in the case discussion when we conference. I understand counsel for Appellant is Carolyn Jabadlo. Am I saying that right? And then Matt Siegel for Michi ACLU. And then Thad Tudor arguing for the state, correct? Okay. Ready to begin?
Good morning, and may it please the court. My name is Carrie Jabadlo, and I represent the defendant and appellant, Sean Doman. I would like to cede 10 minutes of my time to amicus Matthew Siegel from the ACLU, and I'd like to reserve 5 minutes of my time for rebuttal, please. Sean Doman is being criminally punished for exercising his right to record the police in public. Sean filmed a routine traffic stop from a public sidewalk in broad daylight. That is conduct that is fully protected under both the Montana and the United States Constitution. And there are 4 key points that I'd like to make here today. The first point is that there just is not sufficient evidence in the record that Sean knowingly hindered Officer Wiley's investigation. In fact, Officer Wiley testified that Sean did not hinder his ability to issue the citation, and that is on page 67 of your transcript. The second point is that Sean was targeted because he was recording. Officer Manalia was called to the scene because Sean had rolled up filming. And Officer Manalia immediately ordered Sean to back up because he was recording. But Sean's filming was not interfering, and Officer Manalia cannot target Sean for engaging in protected conduct. The third point is that even if this court believes that Sean was ordered to back up for reasons other than the fact that he was recording, his rights were still violated. The state's after-the-fact justification of officer safety is not supported by the record, and Officer Manalia could have just kept an eye on Sean, like Wiley testified he called him to do. But instead, Officer Manalia ordered Sean to back up so far that Sean could not hear any audio.
Counsel, could I, while you're on this point, I think it's really critical. How do we set aside a jury verdict on these facts? Are you asking us to, as a matter of law, say that there was insufficient evidence when a jury has considered this?
Your Honor, I think there's 2 key points to that question. In terms of the sufficiency of the evidence argument, the jury was instructed in Instruction 11 that even if it wasn't a reasonable restriction, that it was not a defense to this. That even if Officer Manalia was not acting lawfully, that was not a defense in this charge. So the jury had no choice but to convict Sean.
There was no objection to that instruction, correct?
Your Honor, the reason this has not been brought, which I think is the heart of your question, as a instructional error issue, is because that is an accurate statement of the law. However, it's the ambiguity in the law, the language between an unlawful order and official capacity that allows for its unconstitutional application.
So but that would still then, by definition, be an as-applied challenge, which has to be preserved.
Your Honor, and it's our position that this was in fact preserved. It was brought to the municipal court's attention that Sean was engaging in constitutionally protected conduct. And we saw that in the discussion about instruction 13. And that instruction is problematic because the court determined that it was a reasonable time, place, and manner restriction before ever hearing the evidence. But
Well,
even
I
if
don't-
this,
First of all, the instruction was proposed by the defense, instruction 13. And I don't think, as I read it, it didn't seem to me that the court was instructing the jury as a matter of law that Officer Manalia's direction was reasonable. The court was instructing that reasonable time, place, and manner restrictions can limit the First Amendment right. And it seems in most cases that have looked at this, in order to back up is a time, place, and manner restriction. And so did the instructions leave room for the jury to determine that this was an unreasonable time, place, and manner restriction?
Your Honor, instruction 13 was agreed to by defense counsel, but with some additional limiting language from Glick v. Cuniff that said that officers are expected to engage or expected to endure a significant amount of criticism. I don't disagree that the instruction was not correct, or I would say that, excuse me, if we are going to instruct the jury that Sean's First Amendment right could be restricted by reasonable time, place, and manner restrictions, then we also needed to instruct the jury what makes a reasonable time, place, and manner restriction, because that is a clearly defined legal concept. And what that means is that first, the restriction cannot be tied to the content. So it cannot be that Sean is being restricted because he is filming. The second part of it needs to be that the state needs to have a substantial government interest. The third aspect is that it needs to be narrowly tailored and leave open ample forms of communication. What was inherently problematic about instruction 13 is that the jury was left to determine what is reasonable. And that was not defined for the jury. And there is, precedent from this court in City of Whitefish versus O'Shaughnessy that a jury can make a determination of what is constitutionally protected conduct. But in that case, this court held that the jury could determine what was fighting words, but specifically pointing to the fact that fighting words was clearly defined for the jury. And that didn't happen in this case. But even more problematically, they were then given instruction 11 that said, even if it was a reasonable time, place, and manner restriction, that's not a defense to this crime. And so that's why this is not just an instructional issue. This is an as-applied constitutional challenge, because Sean was not able to assert his First Amendment protections as a defense to this crime.
So how do we instruct a jury in a case like this?
Your Honor, I think the holding of the court first needs to be that the obstructing charge cannot apply to constitutionally protected conduct, and that would empower, that would provide some guidance for the courts down below. I'm not sure that instructing the jury is always the right option. I think it is an option, but we certainly need clarification from the court that first, subsection 1 of the statute does not apply to constitutionally protected conduct, and subsection 2 does not abrogate defendants' constitutional protections.
Well, but you can have constitutionally protected conduct and be obstructing. I mean, if he was standing between, if he wanted to position himself between Mr. Bearchild and the officer while he's recording, I mean, the recording is without question constitutionally protected, but he's still, I don't think we'd be here. He'd still be obstructing. So just by virtue of the fact that you're engaging in constitutionally protected conduct does not necessarily protect all the actions that you might be taking.
I think, Your Honor, if the conduct that we are evaluating in your example is him inserting himself between the officer and the driver, there's a question as to whether or not that action would be expressive conduct that is actually constitutionally protected. Certainly the right to record, but that doesn't give you carte blanche authority to be, in your example, inserting yourself in an investigation. Now, that just isn't the facts that we have here, and I agree that there could be different analyses in different situations. But the facts here are that Sean is standing on a public sidewalk 10 to 15 feet away from the investigation and not inserting himself. In fact, 3 times he said he would not insert himself into the investigation while being told to back up. And I think that analogy is much closer to, for example, someone asserting their right to Miranda, for example, being asked to answer questions and being told, and saying, no, I'm not going to answer, and then repeatedly being told to answer, and standing strong in behind that constitutional right. They can't then be punished for exercising that constitutional right, and that's really the conduct we have here.
So that's the question, is where's that line, going up with Justice Shea's question, the line of too close where the officer is saying you're interfering? Because the officer here, going to this point, if did he knowingly enter the investigation? The officer told him, you're distracting me from my ability to do the traffic stop or support my partner doing the traffic stop. So he has constructive notice as to the effect that he's causing, even if he's not personally intending that. Mm-hmm. That's my concern, is why is it unreasonable for the officer to say, you can keep filming, you just need to go back to that tree? Because that's what happened. I think if it was a set of circumstances where he said, you can stay here, but you can't film, again, we'd have flipped that fact pattern on its head. So why can't we say officers have the ability to establish a safe buffer around their lawful enforcement activity with the other person, so long as he lets him film from a different distance?
A few points, Your Honor. The first point is that there can be a line, but the line that is created needs to be the same for someone who is filming versus someone who is not filming. And that's to say that if somebody had been standing in their front yard gardening that day, would they have been told they needed to retreat to their house? The only thing that Officer Manalian knew when he ordered Sean to back up was that he had been called to the scene because somebody had rolled up filming. The second point is that just creating a minor distraction to an officer does not rise to the level of unprotected speech. And there is City of Houston v. Hill is a case directly on point from the United States Supreme Court. And in that case, a person was watching their friend be arrested. And to intentionally distract the officers, he said to the police, hey, look at me. Why don't you pick on somebody your own size? And the Supreme Court said, that's protected speech. These momentary glimpses of distractions do not rise to the level of falling outside protected conduct.
In that case, I guess I'm going back to my first question, which is, isn't that a jury question?
Your Honor, it's the state's obligation to be able to identify what conduct in this case were they prosecuting that did not fall within the realm of protected conduct. And they can't identify conduct in this case. But even if they could, it's continues to be problematic that we certainly don't have any assurance that the jury relied on that conduct because of instruction 11.
Right, but go ahead.
But we're not pointing to instructional error.
Your Honor, I'm not pointing to instructional error, you're correct, because, again, instruction 11 was an accurate statement of the law. It's the ambiguity within instruction 11, within subsection 2 of this statute that allows it to be unconstitutionally applied to Sean, that prevents him from being allowed to raise his constitutional defenses in this case.
Which is what gets us back to this being an as-applied challenge, which means we have to exercise plain error to review it.
Your Honor, if this court feels that this claim was not preserved through the conversation that defense counsel had at the municipal court level, then yes, they would have to exercise plain error. And there are 3 tests under plain error review that Sean would only have to meet 1. But we can meet all 3 in this case. And the first is that this is a manifest miscarriage of justice. And what I mean by that is that Sean was exercising a constitutional right. But it wasn't just a constitutional right. It was a constitutional right that the courts have widely accepted serves a public interest. And it's not just any public interest. It's the public interest of keeping transparency and accountability within the government and within policing specifically.
But
Second-
on that, we have 3 law enforcement videos. We don't have Mr. Doman's video. So there's a lot of transparency already happening here. The guy that was pulled over and given a ticket for driving suspended because he was subject to jail had an attorney. So, I mean, the system is providing the transparency. That's where I'm struggling with. This guy shows up on a bicycle, and it appeared to me to be kind of a belligerent attitude, almost like a, what do I have to do to get arrested in this town type of attitude. And that's my concern. Was he actually there doing transparency, or was he there intentionally trying to escalate it to, in fact, undermine the authority's ability to do a traffic stop?
Your Honor, in terms of him exercising his constitutional right to record, I mean, I can't speak to his subjective intent, but he did 3 times state that he would not interfere after being approached by Officer Manalia. He was going back to the purpose of whether or not this is a manifest miscarriage of justice, which is, I think, where you're struggling.
Yeah.
Is that it also calls into question, if it's a manifest miscarriage of justice, even if there was still accountability within policing, his ability to create some transparency is being hindered by, hindered by the government. But let me take us to the second prong, because I think that will also speak to your question, which is to say that it calls into question the integrity of the process. And Glick versus Cuniff, I think, has a quote that is right on point with this. And it says, "The freedom of expression has particular significance with respect to the government because it is here that the state has a special incentive to repress opposition and often wields the most effective power of suppression. That is particularly true of law enforcement, who are guaranteed substantial discretion that may be misused to deprive individuals of their liberty." And what they're saying is the state and police officers specifically are uniquely situated to use the criminal justice system to repress free speech. And if we allow that to happen at speech that is specifically targeted towards transparency in policing, that calls into integrity the entire process. And the last prong is the fundamental fairness prong. If we leave, and whether or not we would leave unsettled the question of fundamental fairness. And I, again, think this brings us back to subsection 2. If we continue to leave subsection 2 ambiguous, meaning that it's just okay for the state to argue that constitutional rights are not a defense to this charge, that really leaves open a question of fairness as to how people assert their constitutional rights against these charges.
Well, I don't want to use your time. I'll ask him.
Oh, go ahead. I'll just point on subsection 2, one other thing I'd like to point to is that the argument in my briefing is that it should apply only when there are instances of force or the threat to use force. And I would point this court to State v. Howard, where it considered a similar argument in the context of the resisting arrest statute, and said in that case that subsection 2 was intended to reinforce the notion that force cannot be used.
That was us adopting a code from another state, but it didn't show that we adopted that committee's comments. We've seen other instances where we've not followed the exact interpretation from a commentator or a committee from California and from Illinois. So plain text of that statute doesn't necessarily support your argument.
Your Honor, the State v. Howard case I'm citing, just to be clear, is the Montana case where
Right.
this court interpreted
The resisting arrest,
the
which is
resisting
different.
arrest statute.
Right.
Correct. The commission comments from the Montana law support directly, or cite, directly to the Michigan comments. So that is why I think that holds authority, or at least persuasive authority, in this context. I just want to use my last few minutes to say that this stop was not unusually safe. In fact, Officer Wiley testified that he believed this stop was just a normal traffic stop. And if we take to the state's position that there is an undermining or an underlying threat of officer safety in every traffic stop, we run the risk of abolishing the right to record in every traffic stop. It is an extreme position to say that because of a routine traffic stop at 11:30 in the morning where somebody was pulled over for a blinker violation, that officers can order somebody to go so far back that they are 3 sedans back. It's questionable whether or not they could meaningfully record to begin with. And they certainly can't hear audio. And we know that audio is a necessary element of the right to record. That is ACLU versus Alvarez. It says it is a necessary component of the right to record. And the state has failed to explain, even if the court believes that Sean was ordered to back up for reasons other than filming, they still need to explain how this was a narrowly tailored restriction and how they left open ample forms of communication. The elimination of audio is where they fail on the ample forms of communication. But in terms of being narrowly tailored, they have never answered the kind of obvious question, which is to say, Manalia was called to the scene, according to Wiley, to be an extra set of eyes and to watch Sean. Why couldn't Manalia stand next to Sean and watch Sean? Why was the restriction the least restrictive option, is to make him go back some 35, 50 feet? And that's where they fail in terms of constitutional scrutiny.
Yeah, and that's the confluence of the criminal aspect versus the civil rights aspect. I don't know when we've ever, in a criminal context, interjected the strict scrutiny analysis. But I don't want to
Well, Your Honor,
counsel's time.
well, perhaps I'll sit down then at this moment, Mr. I will say that it is incumbent upon the state to point to conduct that is not constitutionally protected as the basis of the charge to meet the voluntary act element, right? The reason that Officer Manalia indicated that he wrote this citation was because he said Sean refused to back up. He said that he testified that he issued this citation because of Sean's refusal to leave. Sean was still backing up when he was recorded, or when he was arrested, excuse me. But also, Sean does not have the obligation to abandon his constitutional protections. He's not under a duty to listen to an unlawful order, and that comes from the voluntary act element.
So we interrupted your preview at the outset. Your point 4, you said you had 4 points. You didn't even get to point 4. Can you tell me what it is? I'll write it down. And we won't punish you on time on this.
My fourth point, and which I think is truly the most critical, and going to Justice McKinnon's question, is that constitutionally protected conduct cannot be the basis of the obstructing charge.
Okay.
Thank you.
Thank you, Your Honors.
Good morning, Mr. Chief Justice, and may it please the Court, Matthew
Morning.
Siegel for the amici. For 2 reasons, the jury in this case was authorized to convict Mr. Doman based on a legal theory that was invalid, not as a matter of fact, but as a matter of law.
Can you move your microphone up a little?
Oh, sure, certainly, Your Honor. The jury was authorized to convict Mr. Doman based on a legal theory that was invalid as a matter of law. And so for those 2 reasons, if there were ever a case in which to exercise this court's plain error authority to correct an unconstitutional conviction, it would be this case, not just to vindicate Mr. Doman's rights, but to give appropriate guidance to trial courts so that they can protect the rights of all Montanans. First, by commanding Mr. Doman to obey a no recording zone that was so large that it would have prevented him from hearing an event that he had a constitutional right to record, the city imposed upon Mr. Doman a infringement of his constitutional rights that warrants strict scrutiny, both under the Montana Constitution, because it impermissibly interfered with a fundamental right, and under the First Amendment, because it was a content-based restriction. And second, as Counselor for Mr. Doman alluded to just now, under any level of scrutiny, whether it's strict or time, place, and manner, the city cannot justify the instructions that were given to Mr. Doman. And so, as a matter of law, he could not permissibly, constitutionally have been convicted for failing to follow those unconstitutional commands. And that's because the city cannot explain why, instead of standing next to Mr. Doman, or telling him to stay put, or telling him not to leave the sidewalk, Officer Managlia had to immediately instruct him to back up so far away that he wouldn't have been able to hear the event, and grab the phone out of his hand, and arrest him while he was backing up. Those set of actions simply did not leave available the exercise of the very right that Mr. Doman was supposed to have.
So going to your first point, that seems like potentially a very, very broad proposition that someone can go to any law enforcement scene and record, and they have a constitutional right to do that. And one can think very quickly, I've been on scenes, in fact, where they had to move reporters out of the way. One can think of how that could be abused. Where's the line here? Because the officers are saying we're uncomfortable with him being this close, distracting us or whatever. Where's that line? How do we figure that out?
Sure. It's an understandable question, Mr. Chief Justice, and in trying to answer that, I also want to, I guess, loop in the questions that Justices Baker and McKinnon were asking about. What could the jury have been told here in this case? And in essence, I think the answer to Your Honor's question is there's two basic sets of instructions. If we think of the command that the officers gave here as like police tape, the police tape in every single case cannot say no recording within this line. It has to treat everyone the same, whether they are recording, whether they're exercising a constitutional right or not. They certainly can't treat people worse, require more distance from them because they are exercising a constitutional right. And the second thing is, and this is really where Your Honor's question is pointing me, is how far away can the police tape be? And it cannot be the case that in every traffic stop, the police get to put up police tape, proverbial police tape, that would take people all the way outside of an ability to record anything. And we have cited cases all over the country, including a case, Sharp, from the Federal Fourth Circuit, where someone was recording their own traffic stop. And if the police could do that as a matter of course, then no one would ever be able to record their own traffic stop, let alone someone else's. So what I would say to you, Your Honor, is that if there is a situation where someone is rushing a crime scene, interfering, doing things that bring their conduct, as Justice Shea was pointing out, separate from their act of their exercise of their constitutional rights, if they're getting in the way, if they're literally screaming in the ear of a police officer, those would all be circumstances in which sort of this kind of ad hoc police tape command could maybe be set up. But here, on this record, the court doesn't have to confront those difficult questions, really, because there was nothing that Mr. Doman was doing that even arguably brought him close. He was not only standing, but standing on a traditional public forum. And here's where I would also add that wherever this court chooses to draw the line about this proverbial police tape, the Montana Constitution should have something to say about that. This court has, in its recent cases, has emphasized that if there's something specific about the text or the history of a Montana state constitutional provision that takes it beyond the breadth of the U.S. Constitution, that would be meaningful to the court. And here we have both of those things.
So I have a hard time, though, with that record, because you look at it, he was actually the closest person to the officers. There were other bystanders that were farther away that didn't draw their attention. And so he is the one that they're asking to move. They're not asking him to stop recording. They're asking him to move. And so that's what I'm trying to figure out is why can't we say, okay, experienced law enforcement officer, you're telling the guy, you're distracting me from my duties, please move so I can do that.
So, understandable, Your Honor. The record would certainly be clearer if there had been like 100 bystanders and we could more easily suss out whether Mr. Doman was in fact treated as the same as everyone else. But here's what I would say. So as a threshold matter, I agree with counsel for Mr. Doman that the baseline here is City of Houston versus Hill, which dealt with a statute that made interrupting an officer a crime and said that speech simply cannot, as a matter of constitutional law, ever be made a crime. So then we turn to what was going on here. And for this court to, and I would say anything this court might say was not communicated to the jury in this case. So wherever the line is, the jury was told that it was the guardian of that line as a matter of fact, and that just can't be right. There is a constitutional line somewhere that the jury was not told about at all. Let's talk about what that line is. So on this record, for the court for the action in this case to be deemed content neutral, for us to say that the police tape didn't say no recording, it was just police tape for everyone, the record would have to support a conclusion that the police would have taken the exact same actions, calling for backup, immediately demanding that Doman back up, knocking a phone out of his hand, and arresting him while he was retreating, that they would have done all of that if he had been photographing birds instead of recording the police, or if he had been walking a dog instead of exercising any constitutional right. And I don't think the record supports that. But regardless, even if the court were to conclude as a matter of law that the proverbial police tape in this case applied equally to everyone, we are still left with the problem that as a matter of fact and as a matter of the jury instructions, there's really no reason to believe that the police had to take the action of setting Mr. Doman so far back that he couldn't even hear and possibly wouldn't have been able to see this event. So I understand, Your Honor, there are certainly going to be difficult cases in situations where someone may be, for non-speech reasons, intruding on the police. That's just not this case.
Counsel, can you help us go forward in terms of these types of criminal charges? How do we help trial judges instruct juries correctly?
Certainly, Your Honor.
Unless there's something else more
So-
to talk about.
Whatever you want me to talk about is definitely the most important thing to talk about. So I'm going to talk about that. So I think that there are two basic sets of instructions that this court could give to trial courts, that trial courts that could then give to juries. One is, except in the most extreme of circumstances, it will never be permissible for the police to require more distance from people filming than from people not filming. That's number one. Number two, it will quite often be the case that trial courts should, as a matter of law, decide what is a reasonable time, place, and manner restriction, even if there is a reason to believe that it was a content-neutral application. So that could be done through pretrial motions to dismiss, et cetera. And that's why you have before you many cases in which courts resolve that issue, the issue of time, place, and manner, at the appellate level. But even assuming there's a role for the jury to play on that, the jury should be told, and wasn't told here, that even if the restriction was content neutral, that the City of Houston rule applies, that you can't be criminalized just for interrupting, and that the right to record applies, and so that in deciding whether the restriction was reasonable, they have to consider, among other things, whether it left open alternative channels to record the event. I see that I'm past my time. Happy to answer any other questions that the court may have.
Well, I want to put this question either for you or for you on rebuttal, but just so you know it's on my mind. Here's what I'm grappling with. Glick versus Eisenheimer, okay? Eisenheimer, he's arrested for obstructing a peace officer on a traffic stop, no First Amendment activity. Glick, arrested for only First Amendment activity, no obstructing, okay? So those are the two bookends that I see. If this is a bowling alley, those are the two gutters that I'm trying to stay out of, or at least analogize to. So you can answer that on rebuttal if you want, but just so you know, that's on my mind.
Thank you, Your Honor. Not to be rude to you, but I'm going to try to save as much time as I can for my colleague, and
We'll give you 2 more minutes, don't worry.
Okay. Thank you very much, Your Honor.
Thanks.
May it please the court, my name is Thad Tudor, Assistant Attorney General with the Department of Justice, and I am asking this court to affirm Doman's convictions because there was more than sufficient evidence from which any rational juror could conclude the state had proven the elements of the crime beyond a reasonable doubt. Second, because Doman has not met his burden to establish that plain error is warranted to review his unpreserved constitutional challenge. And lastly, because even if this court invokes plain error review and analyzes this constitutionally, this involves a reasonable time, place, and manner restriction on the right to film police officers. Now, with respect to the sufficiency of the evidence, there's one fact here that makes this case rather unique compared to other authority on this issue, and that is that Doman did, in fact, try to communicate with the occupants of the stopped vehicle before anything was said to him. Officer Willie saw this, and Officer Willie testified, and this is a quote on the transcript on page 56. "I don't know what he is doing there, what his intentions are. He starts communicating with the people inside the vehicle. At that point, I've got a situation I like more than one set of eyes on." Now, the state would contend that is a reasonable conclusion. The logic there is somewhat impeccable for an officer who's concerned with public safety. And then let's look at what the actual restriction that comes later. First off, consistent with what Officer Willie testified, Officer Manali explained, and again, this is a quote. First, I mean, we're responsible for public safety. So if we have somebody that's stationary next to a traffic stop, generally for their safety, we tell them to move along so nobody gets hurt. And in fact, the testimony and evidence establishes that that's what Officer Manali encountered when he arrived at this stop. He sees a guy that in his experienced opinion is too close to the traffic stop. Now, I'd like to go back to Officer, before I get to the actual quotes of the conversations between Officer Manali and Mr. Doman. Officer Manali testified, I explained to the defendant several times that filming was not the issue. It was his close proximity to our stop and the fact that he was distracting me from Officer Willie's investigation, which led to Officer Willie being distracted. That's on the transcript on page 127. That is exactly...
But counsel, Officer Willie testified he was not, that there was no distraction. He might have in the beginning, but during the stop.
I don't recall Officer Willie saying there wasn't a
Well,
distraction.
that he was not obstructed.
He testified, I had to exit my car. When he heard the raised voices, and I think if you watch the videos, you'll see it's when Doman says, I'm going to sue the fuck out of you now, and repeats it. Officer Willie hurriedly exits his squad car. At that moment, you've got obstructing legal process. He's taken his attention completely off the traffic stop. Here's where you get to the Eisenzimmer case. In fact, I'd like to focus on Eisenzimmer for just a moment. Paragraph 11 of that case is directly applicable here. I think you could basically just switch the names of the investigating officer and the defendant.
I think that was out of the ninth, right?
Yes. Excuse me?
Eisenheimer was our case.
Yeah, it was out of the state of Montana.
Out of the Ninth Judicial District Court of
Yes.
Montana. 'Cause
Okay.
I sat on it, but
Well, the ninth, there's a lot of ninths out there.
Now, on,
Our ninth is a lot more important.
on the quote, Your Honor, Holbrook was obviously in the middle of a traffic stop, that's the investigating officers, when Eisenzimmer approached him. Holbrook told Eisenzimmer he was busy and repeatedly instructed Eisenzimmer to keep walking and advised him that he would be arrested if he continued to ask for a ride. This court went on. Prior to arresting Eisenzimmer, Holbrook's attention to the performance of his duties, i.e. the traffic stop, was diverted by responding to Eisenzimmer's repeated requests for a ride. Now, after pointing out that Eisenzimmer's subjective intent really is no part in the analysis, this court stated, the issue is whether Eisenzimmer engaged in conduct that impeded the performance of Holbrook's lawful duties under circumstances that made Eisenzimmer aware that it was highly probable his conduct would impede the performance of those duties. Again, you can switch the names, make Holbrook Officer Manalia and make Eisenzimmer Doman. That applies directly to the facts of this case.
So the
Mr.
question,
Tudor?
go ahead.
If Manalia's demand that Doman move farther away was unreasonable and did prevent him from hearing the encounter, is it your position that the jury instructions afforded this jury any opportunity to acquit him?
It did, Your Honor. In fact, there are all these arguments that he's been precluded from asserting his First Amendment rights. Well, he did assert his First Amendment rights. And the instruction...
But did he, assert and exercise, I guess, are the distinctions that the defense is making. So how did the instruction allow the jury to agree with him that he might have been prevented from exercising his First Amendment right?
Okay, I think what's really important to understand is an underlying fact to all this was at the trial level, this analysis under subsection 2 of 45-7302 became completely irrelevant. In her closing argument, Doman's trial attorney said, we aren't saying the police acted illegally. We're saying he didn't obstruct. Now, in this context, by demanding a jury trial and not bringing a motion to dismiss based on a constitutional as applied challenge, that argument has in fact been waived.
So what was the avenue, to Justice Baker's question, what's the avenue for the jury to find acquittal here?
Well, that avenue was simple. Either the officer's request was unreasonable, or Doman cooperated with him. I think the officer watched the videotape, and what they determined was the officer's approach was not unreasonable. And I don't know why they would. Again, I'm being a little obnoxious here with the quotation, but I think it's important.
But, excuse me, if they determined that it was unreasonable, I mean, didn't then instruction 11 tell them that, I mean, even if the officer was acting unreasonable or illegal, that's no defense?
Well, his attorney said, we don't need the defense. He said, we're not alleging the officers acted illegal. They're not alleging a constitutional violation at the trial level. And by not bringing that up and giving the trial court an opportunity to address that, particularly give the state an opportunity to augment the record. I think as it is, there's sufficient evidence on the record from which one could conclude this was an entirely reasonable request by Officer Managlia, and I'd like to get to that now. His request upon approaching, the first words out of his mouth were, "Hey, brother, I don't mind if you film. Just do me a favor and kind of go a little bit a ways." Oh, okay? That was what he said. That was how he said it. Doman responds, First Amendment, protected activity. The officer has some problems hearing him. He finally hears him. He says, "Right, I agree. Do me a favor and just get out of where we're working, and you can totally film from right over here by this tree, okay?" Those words were spoken clearly, concisely. There is no way Doman didn't hear those words. There is no plausible way he didn't understand the words. He responds, "I'm not interfering." Well, Officer Managlia still doesn't escalate to the point where he feels like he has to use force. He says, "Okay, I appreciate it." It's at this point Doman brings up the opportunity. He says, "I need to be able to record audio." A couple points on this. First of all, I don't think there's any record evidence that he was able to accurately record audio from any position he's in at any point during this videotape or this encounter. No evidence. Maybe that could have been hashed out a little bit had he filed the motion in district court, and the officers could explain some of those things.
Didn't the officer testify? He asked him to move back to a spot where the officer at least couldn't hear, so there's some indication that neither could Mr. Doman?
Yes, hindsight being what it is, Officer Managlia testified. He looked at the film. He said, I think his words were probably not. He couldn't hear what was going on. Doman never made that allegation. The fact, his claim of wanting to record audio was nothing more than pretext to be able to explain to the officer his knowledge of First Amendment rights.
But where's the line? I asked the other side, how close is too close? And Justice Shea asked about you can't be standing between the subject and the officer. But where's too far?
Well, the reason we don't have that answer in this case is because the state wasn't allowed to augment the record. It would have been nice to know, for instance, does Kalispell Police Department always have backup officers to come deal with people who want to inject themselves into a traffic stop? My guess is probably not. Certainly there are other departments where you're never going to have backup available to come and assist with somebody who wants to inject and impose themselves on a traffic stop.
Counsel, do you feel that recording a stop is injecting yourself into the traffic stop?
Recording the stop as close as he was injecting himself into the traffic stop. That was the judgment of the officer at the scene. That was a judgment I would argue the jury necessarily found to be reasonable when he asked him to back up, making clear he had no problem with him taking videotape of what the officers were doing.
Didn't the stopping officer testify that didn't really hinder his ability to issue the driving citation?
My recollection of his testimony is he testified exactly. He said, "This took my attention completely off of the traffic stop." Yes, he was able to eventually issue the citation, which is the exact same scenario you had in Eisenzimmer, but that's not the issue. Legally speaking, the jury was tasked with determining whether he obstructed, hindered, or impaired the investigation. That is what they watched him do in real time with their own senses. Now,
Well, on cross-examination, he said, "Did you believe he impaired your ability to issue the traffic citation?" And his answer was, "I don't think he necessarily hindered my ability to
to deliver the citation, but he's doing an investigation of this vehicle. You can see in the videotape, Officer Willie was genuinely concerned about this car. We can laugh it off and say, okay, maybe dangerous things happen during traffic stops in California. That's not a realistic assessment. He shows up, this vehicle has tinted windows. He described it as a limousine tint. It pulls over, the registered owner is suspended. Officer Willie, and you can see it, he knocks carefully on the window, steps back. He's genuinely concerned. He acts professionally, diligently, and competently, if not downright friendly, throughout this interaction. There would be absolutely no reason for him to need to hide this audio and video recording he's making of this completely uneventful stop. But then he sees Mr. Doman try to communicate with the occupants of the vehicle.
Yeah, what did that hand signal mean?
Huh?
What did the hand signal mean
Well,
that he did?
Doman testified, Officer Willie testified he understood it to mean that he was trying to get the occupants of this vehicle to roll down their window. I don't know of another plausible interpretation. I think that interpretation was certainly reasonable and credible. Now, we get
Isn't this more like, I mean, you keep drawing the analogy to Eisenzimmer, but Eisenzimmer involved one officer who a drunk keeps asking for a ride home and eventually got one indirectly. But isn't this more like Cameron, where you had the two officers, and it is the one officer who doesn't, we held in Cameron that this person who kept refusing instructions from the one officer did not interfere with the other officer's performance of his duties. Isn't that a more analogous scenario?
I would argue the distinguishing feature in Cameron is that that defendant had no idea he was interrupting anything. He was going into a restaurant, didn't know his friend was being investigated for DUI. The difference here is there is no doubt. I mean, this is the whole purpose for Doman approaching the scene is that these officers were engaged in their official performance of their duties. He wanted to become part of this stop, and you see that immediately, as the prosecutor pointed out. He pulls up. If he's there just to document this stop or just to take videotape, he doesn't need to speak to the occupants of that vehicle. And again, had the motion to dismiss for a constitutional as applied challenge been brought in district court, we might have almost certainly would have a more sufficient record explaining the specific concerns that officers were watching unfold in real time.
So maybe that's a good segue to talk about plain error, because I think the defense's argument is that, let's assume, because the record does support that Officer Manalia acknowledged that where he was telling Doman to go, he wouldn't have been able to hear either. He said he didn't know, maybe his phone would have the capacity to record, but he acknowledged he wouldn't be able to hear. So assuming that's the fact, the argument is that the instruction directed the jury that that didn't matter because the defendant can't disobey an even unlawful order. So I think that gets into the realm of plain error because they didn't present that argument below, so maybe you could address that.
Well, both the ACLU and Doman identify the constitutional right implicated for plain error, right? He has a constitutionally recognized right of freedom of speech, freedom of expression to record officers in the performance of their official duties. What I would contend that neither side really explains is how that results in a manifest miscarriage of justice. Doman's argument is, well, Sean has a First Amendment right to record, and that hasn't been disputed. That hasn't been disputed by the arresting officer. It's been acknowledged from day one he does, in fact, have a constitutional right to record. However, where's the manifest injustice when the jury was, in fact, instructed accurately on the law? You heard that conceded. And then his attorney says, we're not saying the officers acted illegally. We're saying he didn't obstruct. And the jury determines, based on the evidence they had, that he did obstruct.
I think the argument that they made is that the state has to have some evidence beyond constitutionally protected conduct, that the basis of the charge can't be that driven by him exercising his right to First Amendment.
No, the basis of the charge was him refusing to move.
Okay, so maybe you could be specific, other than when the initial encounter with Willie, Officer Willie, what conduct can you point to that goes beyond that protected area of First Amendment speech? That would get past a sufficiency argument on the obstruction.
Well, at the point Officer Willie felt obligated to exit his squad car to help his partner and take his attention completely off of the occupants of the stopped vehicle, after it's been explained to him that he is distracting the officers from the stop, so he can't claim he doesn't know that, at that point, that meets all the, that proves all the elements.
Isn't he already arrested? I mean, when the Officer Willie testifies that when he gets out of his squad car, he's over there, he's gonna just help him put the cuffs on. The obstruction has already occurred before Willie exits his car, according to Monoglia.
Oh, it happens almost simultaneously. Manalia testified consistently with what I just said, that he explained several times the filming here wasn't the issue. It was Doman's proximity to the stop. He wanted him to move farther away from the stop. I think a reasonable way to do that might be to ask, hey, would you mind just moving a little farther away for me? Now,
Doman's not interfering with Willie's investigation and citation. He's interfering with Monoglia.
no, he's interfering with Willie's investigation. That's what the evidence shows. That's what Willie testified to. That's what Officer Manalia testified to. By engaging in a loud, verbal, profane fight with an officer who's merely trying to ask you to back up, and doing so in a manner that requires other officers to come and take their focus completely off of the occupants of a stopped vehicle to focus on this individual who has no legitimate basis for being there at that point.
Well, but that's not true. His legitimate basis for being there is filming, right? The question
what
is,
he claims.
so it isn't a matter of do you have a constitutional right to film, it's a matter of do you have a constitutional right to film, in their hip pocket. That's what we're trying to sparse here.
Yes, Your Honor, I agree completely. You have a constitutionally protected right to film the police officers in their performance of their official duties. Now, they actually covered it in jury selection during this trial. Prosecutors, are there times where you think that this might be not be an absolute constitutional right? One of the jurors says, well, I think if you're interfering with the officer's stop, that might be a point where that becomes a little too much, something to that effect. But that's what the evidence shows here.
So the constitutionality of it is, I mean, we're talking about this for purposes of you're talking about the state being able to augment the record and what have you. I mean, the constitutionality of his actions and that issue writ large, I mean, was always part of this. I mean, it was always an issue throughout, correct?
I understand what you're saying, but the issue of whether or not, I'm sorry.
It's all right.
I think Justice Shea's getting to the preservation of the error as applied.
Right.
Okay.
You said it better.
Okay, I'd like to first point out a couple of things with respect to plain error. First of all, the argument on plaintiff error represents a complete shift in strategies. They argued below, or Doman argued below, police weren't acting illegally. I just didn't obstruct. Now they're saying, well, no, wait, the police did act illegally. They violated your constitutional rights. With the gap between linking that to a manifest miscarriage of justice comes in the instruction that was given by the district court at defense counsel's suggestion, which accurately recites the language of Glick v. Cunoff. Says a citizen's right to film, the instruction that was given says a citizen's right to film government officials, including law enforcement officers, in the discharge of their duties at a traffic stop is a well-established liberty safeguarded by the First Amendment. It is not a violation of the law to film a peace officer conducting official duties while enforcing the law. However, the right to record police activity is not without limitations. It may be subject to reasonable time, place, and manner restrictions.
And then is the right of the police, not the right, but if you have a right to record, and to record not only what can be seen, but also what can be heard, does requiring the person to move beyond what can be heard violate? And then when you have to comply with subsection 2 of 457302, that it's not a defense, that the law enforcement officer asked him to move beyond the point where he could actually hear what was going on, doesn't that create kind of a tension that implicates the fundamental rights that are at play here, and that also makes the instruction, which matches subsection 2, a facially unconstitutional application of the law?
I'm sorry, Your Honor, facially unconstitutional?
Well, that's what they're arguing. I mean, not facially, as applied, I'm sorry.
I apologize. Could you repeat the first part of the question again?
If you have a right to record,
And you do.
okay, and with that right to record, you have the right to record not only sight, but sound. But the officer asks you to move beyond the point where you can't record the sound, then doesn't that create the tension where a fundamental right is implicated? And yet we have a law that says it's no defense that law enforcement asked you to go beyond what the Constitution would allow the law enforcement officer to ask you to go beyond.
The officer asked Mr. Doman to move back.
When you're looking at me, the microphone's not picking you up.
The officer asked Mr. Doman to move back. He made it clear. He wasn't concerned
But
with...
then he also acknowledged that the point to which he asked him to move back was beyond what he would have been able to hear.
He acknowledged that in his testimony, but as he's speaking with Doman on the scene, at the scene on the record, the first time Doman says, I need to be able to record audio, he says, you can record it from right over here by this tree. Doman doesn't ever respond and say, no, I couldn't. He doesn't object to that at all. And I would also point out this record is completely devoid of any evidence which would suggest he had the ability to record audio from where he was initially standing. And I don't think that...
But maybe that's a red herring. That's not the point. The point is when the officer asks him to move to a point where the officer knows he can't hear, does that not cause a problem here?
Sure, but I don't think the record evidence supports that the officer knew he couldn't hear. Clearly, at the time, being faced with things in real time, Officer Manalia determined he could hear audio from over by that tree where he was telling him to go, where he was asking him nicely, repeatedly to go.
So I'm kind of changing gears a little bit. You were saying they haven't shown, that they preserved the issue in this case. And I guess, when they're arguing jury instructions, the defense actually argues that additional language should be included in instruction 13, which better assesses out that police officers are expected to endure burdens, and with the idea of better assessing out what reasonable time, place, and manner restrictions are. You don't think that was sufficient to preserve the issue?
No, I think that's entirely different, bringing a motion for some dicta for jury instructions as opposed to bringing a motion to dismiss because a statute was unconstitutional as applied. That's clearly a court issue, that's clearly a pretrial issue, something that can be resolved short of trial, and that's when the motion should be brought. The motion for the instructions in Glick v. Cunoff was absolutely not. It was not the motion that counsels. It did not preserve the issue of whether this was constitutional as applied because the district court never got an opportunity to take testimony and to evaluate under those circumstances. And unless there are other questions?
So, court's limited jurisdiction, as I understand it, can't declare a statute facially unconstitutional. Is that accurate?
That's my understanding.
Okay. does that, I know this is an as-applied challenge, but is there any issue there as far as why we would consider plain error? I mean, plain error is often a shift of strategy. That's not uncommon. So that's what I'm wondering about.
You know, again, I'm sorry, Judge, one more time.
Just wondering if the fact that you can't facially challenge a statute in a court of limited jurisdiction, whether that has any kind of quelling effect on other constitutional challenges, and we should consider that when looking at the plain error question.
I think the question that the chief is asking also is that would the court, in the trial court in this case, have been able to make a ruling on the as-applied constitutional challenge?
I think there's sufficient evidence in the record. I think likely the record would have been augmented, and you would have had the officers talking about, wait a minute, I've got this guy who right off the bat is trying to speak with the occupants of the stopped vehicle. I understand, Officer
But
Maloney.
there's nothing in the limitation of the court's authority that would preclude it from answering the question, is, I think, the question. Is that, Chief, am I kind of getting
Yeah.
your question?
Can a municipal court rule on an as-applied constitutional challenge, whereas they cannot rule on a facial constitutional challenge to a statute? Does that make sense?
That makes sense. I'm not able to speak intelligently.
Procedurally, are they barred from from an as-applied challenge at the municipal court level?
I'm not aware of any procedural bar of an appeal. They did appeal to district court in this case. That's required. District court said you waived it. You didn't raise it before the trial court.
Okay.
I thought there was a lot of discussion of Glick in the transcript before the Justice Court, but
Your Honor, and I had some quotes from State of Hawaii versus Russo. I apparently lost them on the way up here. But I think that sets out a real nice job of collecting the federal circuit decisions and then submitting, synthesizing all those opinions and then submitting a rational test that I think applies consistently with the precedent in Glick v. Cunoff and those other federal cases.
All right, any further questions? Thank you. We gave you back your rebuttal time that we took from your colleague.
First, just to speak to your last question, Chief Justice, in terms of preservation, I do not believe that a lower court is barred from ruling on an as-applied challenge. However, I would say that had, for example, the trial counsel made a motion for a judgment of acquittal, arguing that there is no unconstitutionally protected conduct that can be the basis of this charge, therefore it should not go to the jury, which is absolutely a motion they could have made, the record would be no different. We would still have the exact same record before us today and on appeal. And so in speaking about whether or not plain error is an appropriate review, I do not, there's no reason to believe that had this been preserved in a different fashion, there would be a different record before this court. I also want to clarify my response and just talk about jury instruction 13. I don't want to leave this court with the impression that jury instruction 13 was correct and jury instruction 11 was the only issue. Jury instruction 13 was flawed as a matter of law. And it started first with the fact that the municipal court determined that a reasonable time, place, and manner restriction was the appropriate test. That came prior to hearing any evidence in this case. So prior to determining whether or not that should have been a content neutral or a content-based restriction, right? was Doman ordered to back up because he was filming, which would then require strict scrutiny. The court determined prior to hearing anything that intermediate scrutiny applied. That is inherently problematic. They applied the test without first hearing the evidence and determining which test should be applied. And then the jury was not told that they too would need to, that they then would need to determine. So again, a reasonable time, place, and manner restriction is one that does not tie back to the content of the restriction. And so in order for intermediate scrutiny to apply, it cannot be a content-based restriction. So the first prong would be that it cannot tie back to the content. So it cannot be imposed because Doman is filming. The second part of the reasonableness would be that the government needs to have a significant government interest. Then it would need to be narrowly tailored to that interest and leave open ample forms of communication. Those are clearly defined legal concepts that we have to define reasonableness that the jury never heard. Unlike City of Whitefish versus O'Shaughnessy, where fighting words was clearly defined, and this court said, well, in that instance, the court can decide. Chief Justice, I want to go back to your question in regards to the parameters between Glick versus Kavanaugh and Eisenheimer. First, in terms of the facts of the case, Glick versus Kavanaugh was a case that happened in Boston, there was a violent arrest occurring in a public park at night. And in that case, they held that a 10-foot distance was a reasonable distance. That was the limit in that case, during a violent arrest at night in a public park. Eisenheimer was determined on a sufficiency basis, not as an as-applied challenge, but I think if we put an as-applied context to it, we have totally different behavior than we have here. I think the first question we have was, would Eisenheimer's constitutional protections even be invoked, right? Is he even entitled to constitutional protection? And I'm not sure he would have been, because it's his approaching the vehicle that is, and not the content or his speech that is the problematic behavior.
You don't have a constitutional right to a ride home?
I'm not going to make the argument that you do today, at least.
We're talking about Butte on St. Patty's Day here?
Yeah.
Well, there are exceptions.
So here's my question on, first of all, on Glick, let's start with that. It wasn't so much the 10-foot distance. It appeared to me that the triggering issue was when he confirmed to the officer he was recording, and then he said he arrested him on the wiretapping statute or something like that. So it was very much the constitutional activity of recording that triggered it. I didn't think there was an allegation that he was actually interfering in the arrest. I think Eisenheimer is a much more interfering scope of conduct than what we have here. But the reason I like that comparison is because there isn't the invocation of protected activity. It's simply interference, even if it's just, not necessarily intentional. So that's what I'm trying to understand between those two barriers.
And I think, Your Honor, you hit on it exactly, that there wasn't the invocation of the constitutionally protected conduct in that case that we clearly have here. And I think that is the deciphering factor, because once we put a limitation, this is U.S. versus Alvarez, once we put a limitation on that constitutionally protected conduct, there needs to be a direct causal link between why are we restricting that conduct, what is the perceived harm, and be able to justify that restriction that we then impose.
Right, and which goes back to Justice Shea's question at the beginning, which is you can be engaged in something that's constitutionally permissible, but if you're also doing something that is impermissible and you're arrested for that, then we have to figure out which was actually the trigger here, which is why we're here today.
Thank you, Your
So
Honor.
any last thoughts on that point?
My last thought on that point is the conduct that they have been pointing to in this case is the slight distraction of Wiley, which clearly still falls in the realm of constitutionally protected conduct under City of Houston v. Hill.
Okay. Any further questions from the court? Okay. Thank you, and it is submitted.